Good afternoon or good morning, everyone. Welcome to today's iteration of the Live Employment Law Q&A. My name is Teilen Celentano. I'm an associate and employment lawyer with Samfiru Tumarkin LLP based out of the Toronto office. If you have any questions today, please feel free to comment or ask your questions directly through Facebook, LinkedIn, Twitter, YouTube, or go to employmentlawyer.ca. Email us at help@employmentlawyer.ca or give us a call at 1-855-821-5900. I'd like to start today by talking briefly about the news that ATS will be acquiring the water purification company Avidity Science for $265 million. So whenever one company acquires another, there's oftentimes a lot of change. That includes both with who stays on and who leaves, but also with the duties and responsibilities that individual people are assigned to. Oftentimes, in some departments like human resources or in accounts payable, there isn't a need to double the size of the group. Therefore, a number of people are laid off. In that instance, those employees who are laid off, terminated, or fired, whatever word you want to use, they are all entitled to severance. How much severance someone is entitled to depends on a number of factors, most notably their age, their length of service, and the availability of similar employment. But it can be as much as 24 months' pay. So if you're in a position where you've been let go as a result of an acquisition, give us a call and one of our lawyers will be able to help you out. Similarly, if through this transition period, your new company attempts to impose significant changes to the circumstances of your employment, you can also pursue a severance via a constructive dismissal claim. Different types of changes that can happen are they change where you work. So you may have worked at one location for the past 10, 15 years. As a result of this change, they're making you switch locations. If that new location, new office, new plant, new warehouse is significantly further or will take you significantly longer to get to every day, you can pursue constructive dismissal on that basis. Similarly, if the company attempts to enforce a change of hours or takes away certain management responsibilities, you can also pursue a constructive dismissal claim. Lastly, oftentimes during these transitions, the new company will have their new employees / the purchased company's old employees sign new employment contracts. While there's nothing inherently wrong with signing a contract, new employment contracts can oftentimes introduce new terms to someone's employment that can have a profound impact on someone's entitlements in the event they are terminated or laid off. Certain clauses to keep an eye out for are clauses like layoff clauses. Generally speaking, when employees are laid off for the first time, they have the right to treat that as constructive dismissal. But if they sign a contract that allows a company to lay them off, they are prevented from doing so for 13 weeks. Similarly, a company can introduce a new termination clause, limiting someone's entitlements to only the amounts under the Employment Standards Act, which max out at roughly 34 weeks rather than 24 months. So if your new employer is asking you to sign a contract, don't sign it. Again, give us a call, reach out to us at employmentlawyer.ca. One of our lawyers will be able to take a look at that new contract and tell you exactly what you're being asked to sign away. Christina on YouTube asks, what is considered significant change? If they add new duties to your job, is that considered significant? So Christina, it depends on what the duties are. If they are transitioning you from accounts payable clerk to an accounts receivable clerk, the job is largely the same, but it's just somewhat different, then no, that's probably not a significant change. But if they are adding on significant duties, meaning duties that will take you 10, 15, 20 more hours a week to complete, they're not giving you any additional pay for it, then that can be a significant change. It's really a case-by-case analysis, and we really need to see the whole facts of someone's employment in order to assess whether or not a change is significant. So if your boss is asking you to take on significantly more duties, then it's best to give us a call or reach out to us, and one of our lawyers will be able to help you out and ascertain, whether those changes are significant enough to allow you to pursue a constructive dismissal claim. Question from QA123 on Reddit. My employer let me go stating lack of work, but reposted my job at a lower rate of pay. Is this a case of wrongful dismissal? So yes, QA, that's absolutely a wrongful dismissal. Just because the company wants to pay you less doesn't mean they can let you go without any severance. So while there's likely nothing we could do to get you your job back at that same rate of pay, you do have the right to pursue a wrongful termination claim against your former employer. How much severance you would be entitled to will depend on the individual circumstances of your employment, but absolutely reach out to us and one of our lawyers will be able to help you out. Question from Skippy on YouTube. I have been given a contract for a part-time job that includes a 3-year non-compete clause. I'm worried about accepting this position because of this. Should I be worried about taking the job? So Skippy, a couple of years ago, the Ontario provincial government introduced new legislation that made non-competition agreements unenforceable, unlawful for the vast majority of employees in Ontario. So what that means is that when an employee such as yourself signs a contract that includes a non-competition clause, it's unenforceable. Now, there are certain circumstances where such a clause would be considered enforceable. And, without all the details of your case, I'm unable to definitively say worry about it, don't worry about it. But generally speaking, they are unenforceable in Ontario. If you are worried about it, feel free to reach out to us at employmentlawyer.ca. One of our lawyers will be able to review everything and they'll be able to tell you definitively whether or not it is enforceable, whether or not it's something you need to worry about, whether or not it can have an impact on your future employability. Annabella on YouTube asks, it's my understanding that after you work more than 10 years, after you have worked more than 10 years in a company, you will receive at least 1 year of salary. Is that correct? So Annabelle, I'm not sure exactly what you mean. What I think you're asking is if you've worked at a company for more than 10 years, in the event you are let go, you're entitled to at least 1 year's salary. If that's what you're asking, unfortunately, the answer is no. How much severance someone is entitled to depends on a number of factors: their age, their length of service, availability of similar employment, as well as other factors that may make finding work for one person more difficult than others. For example, if they work a physical job, but they have a physical disability kind of thing. A carpenter who can no longer lift more than 5 kilograms will have a harder time finding a new job than a carpenter who has no lifting limitations. So there's no rule of thumb. There's no hard and fast rule. The only thing is the Employment Standards Act. The Employment Standards Act sets the minimums that someone is entitled to. So a 10-year employee who works for a pretty large company, they'd be entitled to a minimum of 18 weeks, which is, it's a little over 4 months. But that said, there's significantly more that you're entitled to under the common law. It's not, more than 10 years means you get a year, but, it can be that much for a 10-year employee. It really just depends on the circumstances of someone's individual employment. Justin asks, can my employer change my commission, lower it, even if there's a clause in my contract saying that they can do this? So the clause in your contract likely says, Justin, that they can make changes to the commissions or variable compensation structure at their sole discretion. So it would depend on how big that change is. There is some courts do give companies some leeway to adjust a commission plan or a variable compensation plan, especially when there is a contract that says they're allowed to do so, like this. So how much they're lowering it depends. Would depend on whether or not you have the right to pursue a constructive dismissal claim. So if this change would result in a 1% to 2% reduction in your annual rate of pay, then no, you probably can't pursue any constructive dismissal claim against the company. Whereas if the change would result in a 20 or 30% reduction, then you could. Importantly, we can't force the company to reintroduce or re-implement their old commission plan. Instead, what we could do is we could allow you to pursue a constructive dismissal claim, treat your employment as if it's been terminated by your employer, thereby allowing you to pursue employment elsewhere and hopefully recover a severance package. Question from DXL. Can my employer force me to relocate to a new facility? It's a little over an hour away and will make things much more difficult for me. So it depends on how long your current drive is. So if you're a DXL, if your current drive is 5-10 minutes and the company is now asking you to drive over an hour each way to go to and from work, then it's likely that you can pursue a constructive dismissal. Our courts have on multiple occasions analyzed cases like this, and it really does end up being a case-by-case analysis. The courts will look at how long the current drive is, right? So if you're already driving 45 minutes and they make the drive 65 minutes, it's likely not a big enough change for it to be deemed a constructive dismissal. Another thing that matters is where you live. Our courts have said previously that people in the GTA, so the Greater Toronto Area, are the expectations already that they will drive over an hour to get to and from work. Whereas if you live in Northern Ontario, North Bay, Sudbury, Timmins, the expectation is not that you'll drive an hour. So it's really done on a case-by-case analysis. But driving, if your drive went from 5, 10, 15 minutes to now over an hour, it's likely that you would be able to pursue a constructive dismissal claim. In order to do so, you'd have to contact one of our lawyers. You can reach out to us at employmentlawyer.ca. One of our lawyers will be able to help you out and let you know what your rights are and whether or not you are able to pursue a constructive dismissal claim. Because Christina is asking a follow-up. Can my employer change in office days whenever they want? My contract says 2 days in office, and historically it has been Monday, Tuesday. So it would depend on why they were making those changes, Christina, and how much notice they gave you. If they were just changing it from Monday, Tuesday to Wednesday, Thursday, and gave you a couple weeks notice, then yes, they could likely make that change unilaterally. That's wouldn't be considered a significant enough change for you to pursue a constructive dismissal claim. On the other hand, if they said, well, we want you in office 5 days a week, it's no longer hybrid, it's now full-time in office, that change would likely be significant enough for you to pursue constructive dismissal claim. So which days specifically you're in the office, they can probably change that, provided they give you a few weeks, a few months notice. Whereas if they try to go from 2 days to 5 days, that's probably big enough for you to trigger a constructive dismissal claim. Marilyn on YouTube asks, can an employer make changes to your position and pay if you are still in a probation period? So it's important that people understand that probation periods can't last indefinitely, and generally they're limited to 3 months. If your employer does wish to make your changes to your position or pay during that period, technically they can't. Technically, any significant change or reduction in pay would result in a constructive dismissal. However, if you're let go during a short probation period in good faith, then you may not have any entitlement to severance. So it's a really difficult position, but anytime an employer is trying to impose significant changes, whether to your duties, to your position, or to your rate of pay, it's best to give us a call or reach out to us at employmentlawyer.ca so that we can review the circumstances of your employment and advise what your rights are in a case like that. Without all of the facts, it's difficult to know. What your entitlements could be. Barb on YouTube asks, my company fired me for misconduct and used an old write-up from a few years ago to say they had cause. Is there anything I can do, or do I have to accept a for-cause termination? Well, Barb, in Ontario, terminating someone for cause is an extreme remedy that is very rarely, if ever, justified by the courts. So in your case, it sounds like they're relying on it. You say they're relying on an old write-up. So in order to terminate someone for misconduct, and again, it varies on the level of misconduct, but generally, the company needs to have a prolonged history of disciplinary action, more than just one single write-up from a few years ago. Moreover, if it was a few years ago and you had rectified that issue and nothing went wrong since, then they can't now rely on that to say they had cause. Our courts have frequently said that terminating someone for just cause is the capital punishment of employment law. And while that is hyperbolic, it does illustrate how serious a remedy that is, how serious misconduct needs to be in order to justify terminating someone for cause. So the case law has shown that it's very, very difficult for an employer to prove cause. And oftentimes when someone is terminated for cause, and they subsequently file a wrongful termination lawsuit, they are then awarded a severance package. So if you've been terminated for cause, give us a call or reach out to us at employmentlawyer.ca. One of our lawyers will be able to, get a full scope, a full view of everything that's going on and be able to help you out and advise on what your entitlements might be. Question on Facebook from Shauna. Shauna asks, how is severance calculated if an employee has been off work on medical leave for more than 12 weeks prior to termination? Well, Shauna, it depends on the circumstances of someone's employment. So if it's a situation where someone earned a set base salary, then we'll just use that base salary. So if you have a contract that says you make $65,000 or $60,000 a year, breaks down to $5,000 a month, and we do it that way. On the other hand, if you don't have that, we can look to past year's T4s. So if it's a situation where you've been off work for the past 12 weeks, but you had full working years in 2022, 2021, and 2020, we'll look to those T4s in order to ascertain how much you earn. It's pretty much always one way to work around it. We can even look at a most recent full pay stub. If that's representative of a normal week, i.e. 35 or 40 hours a week, we could just multiply that out by 52 weeks in a year, and we could get your annual earnings. So there's a lot of different ways we can do it. Just because you've been off on a medical leave for 12 weeks doesn't mean we can't calculate how much severance you're entitled to. Okay, next question from YouTube. Is an employer allowed to put you into a pre-retirement position if you have no plans for retiring any soon? So I don't know what you mean by a pre-retirement position, but to me that screams discrimination. So under the Ontario Human Rights Code, employees are prevented from being discriminated against on a number of grounds. Age, gender, sex, disability, gender expression, and a number of others are all protected grounds under the Ontario Human Rights Code. The applicable one in this case is age. It sounds that, in your workplace, employees in these pre-retirement positions to kind of funnel them out of the workplace. That's discrimination, and that's unlawful. The company is not allowed to treat you differently because of your age, nor are they allowed to enforce a minimum retirement age. Again, that's provided you're not in a union. So if you've been put into a pre-retirement position and it's been announced to the company, you could probably have a case for constructive dismissal because that's discrimination on its surface. It's clear. But on the other hand, you have no obligation to retire at a certain age if the company tries to impose it. So if you've been put into a pre-retirement position, reach out to us, give us a call. One of our lawyers will be able to advise you on what your individual rates are in your case, Juanita. But no, employers are not allowed to impose pre-retirement positions. They're not allowed to impose a mandatory retirement age, nor are they allowed to in any way change your position because of your age. So, because doing so is discrimination and contrary to the Ontario Human Rights Code. The question from Caitlin on YouTube. I've been having some mobility issues. My doctor suggested reducing my work hours. Is this a form of accommodation? Can my employer deny this request? So if reducing your hours at work, so going from 40 hours a week to let's say 30 hours a week, 5 days to 3 days, is something that is medically supported, then yes, that is a form of accommodation. It's likely that in order to receive it, you and your doctor would need to fill out certain forms in order to allow your company to accommodate you. But yes, that's absolutely something you could request. If your employer wants to deny it, they have to prove that giving you this accommodation would cause undue hardship on the company. Now, what is undue hardship? It's hardship that is more than just inconvenience. It's more than just business expense. It needs to truly jeopardize the functioning of the company. So obviously, I'm not sure what role you occupy or what you do on a day-to-day basis, but generally speaking, it's hard for companies to prove undue hardship, especially in a case where you just need to produce your hours. So in your case, tell your company that you need accommodation, that you need reduced hours, ask for the accommodation form, ask to be accommodated. And if they say no or deny the request, then you can pursue a constructive dismissal claim. It's important, though, Caitlin, that during that process, you're doing everything in writing. Oftentimes, these types of cases can end up being litigated, can end up in court, and you want to have the best paper trail you can in order to ensure you're protected. So it's not a bad idea to reach out to us if your employer says they can't accommodate you. But between, as you're requesting this accommodation, it's okay to have conversations verbally, but then follow them up in writing. Try to create the best paper trail you can so that in the event that they say no, you have a stronger lawsuit. Question from Carlos on YouTube. Does severance pay change depending on the size of the company? So severance pay, in employment law really has two meanings. The first is at common law, and the second is under the Employment Standards Act. So at common law, severance pay is another word for payment in lieu of notice of termination. And that doesn't depend on the size of the company. Excuse me. It instead depends on the circumstances of your individual employment. So your age, your length of service, availability of similar employment, etc. One of the factors is not the size of the company. On the other hand, under the Employment Standards Act, which sets out only your minimums, the minimum employees are entitled to when they are terminated, the amount of severance pay you're entitled to does depend on the company's total payroll. So under the Employment Standards Act, you're entitled to 1 week's termination pay per year of service up to a maximum of 8 weeks. And then if you've been at a company for longer than 5 years and the company has a total payroll of over $2.5 million, then you're entitled to an additional 1 week severance pay. And that maxes out at 26 weeks. So under the Employment Standards Act, yes, your severance pay does depend on the size of the company. On the other hand, at common law, it doesn't. Most employees are entitled to damages in accordance with the common law. So 9 out of 10 times the size of the company doesn't matter for our purposes. And if a company is trying to say you're only entitled to your amounts on the Employment Standards Act, there's a very good chance you're incorrect, even if there's a contract that says it. Employment contracts are oftentimes written too broadly or written to contravene the law, and we can oftentimes get around termination clauses or other clauses in contracts. So feel free to give us a call. If you're not sure what your company's total payroll is, a good rule of thumb is that if they're over 50 employees, they're probably over $2.5 million. The quick math is that 50 employees making $50,000 a year is $2.5 million. So if there's more than 50 employees in your workplace, or maybe there's a few less, but everyone earns a lot of, you're a high earning company, there's a good chance you're over that $2.5 million threshold. JT on YouTube says, I signed an offer letter for hourly pay and was putting in over 50 hours weekly. A month later, my rate of pay was changed to a salary. What can I do? Well, Jay, if that change is going to have a substantial impact on the amount of money you earn, you do have the right to pursue a constructive dismissal claim. So if you were putting in 50 hours a week at $20 an hour, so you're making $1,000 a week, and now because of this change, the company has reduced you to a salary of $800 a week. That's a significant change. That's 20% decrease. You can't pursue a constructive dismissal claim on that basis. Unfortunately, in Ontario, employers always have the right to terminate employees. So if you attempt to refuse this, refuse that change or not sign a new contract, then there's a chance that they could terminate you and we couldn't get your job back. The last thing to highlight, though, is that non-managers in Ontario are entitled to overtime pay, even if you're on a salary. So if you're putting in more than 44 hours a week, every week, then for those last 6 hours, you're entitled to additional pay. So if you're still putting in those hours and you're not getting paid, assuming you're non-management, then the company isn't paying you as much as they should, and one of our lawyers could help you out in order to recover that overtime pay. All right, it's 11:25 now, so we're just coming up towards the end. I'll answer one or two more questions, and then that'll be it for today. Tanya on Facebook asks, if a company owes money to its suppliers and closes the plant that you are working at, are employees still entitled to severance if they are still open and operating in other locations? So Tanya, it depends on the corporate structure of the company. If the corporate structure is such that it's just one big company operating at multiple different locations, then yes, you're still entitled to severance pay and you can pursue the corporation at large for those payments. On the other hand, if they're individual franchises or individual separate companies where, the warehouse you worked at is just one corporate, is the only location in that corporation, and then there's another related one where you never worked, then it may be difficult. That said, it's always best to give one of our lawyers a call so we could help you ascertain what's what and what you could recover. So reach out to us at employmentlawyer.ca, Tanya, and one of our lawyers will be able to help you out. All right, last question today from Helen. A young man replaced my work as a woman aged over 50. How can I justify sex and age discrimination? The employer also gave a performance letter to a man aged over 70. So, Helen, in a situation like yours, it's difficult to really know. Just because somebody got replaced by a younger person doesn't mean that there's inherently discrimination. A case like that, you would really need a smoking gun. Similarly, if the employer gave a performance improvement letter to a man over 70 who was actually performing below expectations, then that's a completely justifiable action taken by the employer. So in order to justify or to prove discrimination on the basis of sex, discrimination on the basis of age, we would need to show some tangible action, some tangible evidence that the company has done something to discriminate against you, that there's a targeted plan to make the workforce younger, to make it whether more men or more women. Just because someone got let go and then were replaced by a younger person, or just because someone got let go and then were replaced by someone of the opposite sex, doesn't necessarily mean there's discrimination. We would need a lot more in order to convince a judge that that you had been discriminated against. Got time for one more quick one if anyone has any questions. All right, last question for today from Reddit. Now, I was terminated a week ago after telling my employer that I was having medical complications with my pregnancy. A few days later, they sent me an email for a return back to work. I'm not sure what to do in this situation. I feel I was let go because of my medical condition. So if the company has terminated you, and they did that in writing, right? So they sent you a letter, said, hey, we're letting you go. They can't rescind that. That's not some employer can't let someone go and then change their mind. So if you've already been let go, you don't have to go back to that work. And if it was shortly after you told them you're having complications with your pregnancy, then there's a chance that they've discriminated against you as well on the basis of your family status. So it sounds like there's quite a few if-then statements in your question. So absolutely best that you reach out to one of our lawyers. But generally speaking, you wouldn't have to return to work, and you would be entitled to pursue a full severance package against your employer, and that could be as much as 24 months, depending on the terms and circumstances of your employment. But you may also be entitled to pursue damages for circumvention of the Ontario Human Rights Code. So you've got what sounds like a complicated but strong case. So reach out to us, and one of our lawyers will be able to help you out. So that's it for me today, guys. Thank you everyone for joining. Again, my name is Teilen Celentano. I'm an employment lawyer and associate at Samfiru Tumarkin LLP, based out of our Toronto office. Please check if you have any more questions that I wasn't able to get to. Please feel free to check in tomorrow at 1 p.m. for a live employment show with Leo or Samfiru. You can reach out to us at employmentlawyer.ca. By email at help@employmentlawyer.ca, or by phone at 1-855-821-5900. Thank you, everyone. I hope you have a great day.